today as purely being this commercial agreement between two parties. But arbitration goes beyond that. Why does it do so? Please see page 63.
Yes.
Lordships may note the 5 components of arbitration. I will trouble my lords with A, B, and E. Please let me start with A. Arbitration as a creature of the parties. My lords has that, my lords, at 63. May I read?
Yes, please.
Yes. The statement that arbitration is a creature of the parties, that its occurrence, form, and scope are dependent on the will and consent of parties is but part of the truth. Although the arbitration agreement, as any agreement, is consensual within its limited compass, it is also in varying degree depending on the law of the particular jurisdiction. Now, please note, my lord, a delegation of the power of the state to private parties for their private ends. That delegation proceeds on the assumption that the attainment of those ends will also subserve public interest with a sufficiently high degree or incidence to justify such delegation. The basic assumption is, as we pointed out in the preceding section, that arbitration is an allowable extension of the sphere of contract, yet the fact that it is consensual profoundly affects the nature of the award and the value sought to be served by the award, and hence the determination at the ends of the attainment of which the power of the state will be brought to bear. Now please see B, arbitration as an award. The fact that the arbitration process involves a delegation of the power of the state also must be considered in the evaluation of the process, for the exertion of this power will channel conduct within or between institutions as the case may be, and thus have consequences with which society must be concerned. Now, my lord, please see arbitration as a settlement of a dispute. This is what we primarily focus on, to the exclusion of the other elements. Now, please see D, arbitration as a procedure before a tribunal. This also we focus on. Now, please see E, my lord. This is critical, which is why the court's exercise under 34 and 37 must be cognizant of this complexity. Please see E, my lord. Diverse nature of the arbitration process. It will be evident from the foregoing that one of the fundamental propositions of this article, that it is erroneous to assume that the arbitration process remains the same and is uniform wherever the elements of its structure appear. It is erroneous to assume that arbitration is purely a structural concept definable by the occurrence of the elements noted in the definition at the outset of this article. An individual may be identifiable by the presence of a typical sentient anatomical structure. The personality of an individual, however, emerges when he is viewed in a social context. Similarly, the nature of an arbitration becomes revealed when it is viewed in its social context. For arbitration is a chameleon word, assuming varying significance as the social setting in which it takes place. Now, my lord, after this normative exposition, jurisprudential in nature, please see its application to commercial arbitration. That is what today we mostly engage with. Please have with me page 77. I'll conclude with this. Please bear this in mind, my lords. Please see page 77. Please see Roman 10. Nature and role of commercial arbitration. I'll just read this one para and conclude. Yes, may I read? The term commercial arbitration implies the arbitration of disputes arising in the life of trade and commerce. A dispute involves a deviational transaction in which an established customary expected course of conduct fails to be carried out as anticipated. The particular parties to the dispute may or may not have been involved before in similar transactions. At least one of the parties, however, will have performed many similar transactions in the past, so that its behavior will have become institutionalized, and there will thus be a pattern of practice or norm against which the deviational transaction can be appraised. The fact that this pattern of practice, which usually involve an external relation of a business institution, is of little social significance. The significant circumstances to be examined and weighed in determining whether a deviational transaction should be approved or condemned are: first, the nature of the established norm of conduct against which transaction to be measured; second, the nature of any general rules of law relevant to such transaction; and third, the nature of any special rules of law established by the party to govern the transaction. Now, my lord, the next two sentences are pregnant with consequence. Thus, no dispute can be said to be isolated or discrete. The parties may be, but not the institution.
Some of the objectives of the Act, Your Honor, are providing speedy disposal of the disputes, providing for amicable, swift and cost-efficient settlement of a dispute. I'm taking it just an illustration, Your Honor. In my case, I'm just taking the dates. In 2002, an arbitrator was appointed. 2010, the arbitration award was passed. In a cross appeal, one of the claim was allowed. In 2010, the section 34 was filed. 2019, Your Honor, the section 34 was modified by the High Court and a single judge. 2024, Your Honor, the division bench set aside on the basis of Mohammed Hakim judgment, Your Honor. 22 years, Your Honor, has taken place. Your Honor, asking us to go back in a case will be against the very objective of the arbitration. Your Honor, let's take an example in a cost efficient, Your Honor. In a civil suit for 10 crores in Delhi, the court fees will be around 10 lakhs rupees. Whereas in arbitration, if there are 3 arbitrators, the cost will be around 37 lakhs 50,000 plus the other expenses, Your Honor. Asking us to go back after 20 years or 10 years, I will say, and give the same court fees again will be the very against the objectives of the Arbitration Act itself, because it has to be cost efficient. The objective is it should be cost efficient also. Now let's take an example again. Let's say in a 10 crore civil suit or 10 crore dispute, Your Honor, the modification is about rupees 50 lakhs rupees only. Arbitrator has passed an award and the dispute is only about difference of 50 lakhs. Now that arbitrator, if we will ask him to set aside that arbitration award, then this amount of 50 lakhs rupees will go only towards the cost of the arbitration itself. So the objective is to see the finality of the judgment should be there, where the arbitrator should feel that, where the court should feel that sending the matter back will itself defeat the very purpose of modification itself. The court should allow in that way, in those matters. Okay, please. That's all.
Was IFPN IF 40905. And a summary of my submission is that the power to modify comes from 34(4). And it should be done only in the manner which is prescribed by the statute. 34(4) does not entail that the court should take cognizance of the matter, because the moment it takes, then doctrine of merger starts applying, which is not anticipated by 34. It's a hands-off approach situation, but the Honorable Court will always have the power to tell the arbitrator to modify the award. That's my humble submission. Now, it is also important to note at what stage and why should 34(4) be resorted to in the first instance. Of course, the learned seniors have already submitted why we should first try to save the award. And that principle actually comes from the pro-enforcement bias that is there in 34. There's a judgment of Vivek, which is under section 48 of this act, where my lords have held, looking at the language, usage of the word may in section 48. And they say that, look, first endeavor should be to enforce the award, even when we agree that certain grounds for objections are made out, because the word uses may. The same expression is borrowed in section 34 also. Section 34 also says an arbitral award may be set aside by the court. So therefore, the first endeavor has to be to save the award. The additional reasons why I'm making this submission is also the principle of minimal curial intervention. And second would be doctrine of proportionality means. Now, it may be debatable what is more minimum curial intervention. Is it simpliciter setting aside or keeping the matter with itself under 34(4)? My humble submission is that not setting aside the award or not using the draconian provision of setting aside the award actually confers with the minimum curial intervention principle under section 5 of the Arbitration and Conciliation Act. And this is also in conformity with the doctrine of proportionality as well, where for minor errors or small errors or curable defects which can be corrected, resort to 34(4) must be made before 34(2), my lords. Now, my lords, one thing that comes in the way is the sheer language of section 34(4). Now, it has been submitted at the bar, my lords, yesterday, and there's a judgment also against me. Kinari Malik, my lords, 3 judges. And I just read the provision. On receipt of an application under subsection 1, the court may, where it is appropriate, and it is so requested by a party. So this expression, I think it fell from Justice Kumar also yesterday, that it is so requested by a party, my lords, this has been interpreted by my lords to say there should be a written application. In my humble submission, my lords, that may not be the correct position. Because number one, if they wanted to say application, they would have used the word application because they've used the word application at least 10 places in the statute. So they deliberately avoided the word application. Number two, my lords, in my humble submission, this is not a precondition for using the power. This is more of an ex post facto seeking consent / compliance. Now, the reason for such a submission is that since the court is duty bound to save the award, therefore, party taking that initiative should not be that condition. Number two, the language itself says, first the court will see where it is appropriate and it is so requested by a party. So I'm not saying that this and should be or, but I'm just saying a proper interpretation of it is so requested by a party should mean ex post facto consent. Now, why such a provision is there? Of course, my lords, learned SG took my lords to the preparatory articles, and those discussions, etc., do not dwell upon why there should be this power of seeking a request or consent of the parties. But my lords, my submission is that it should not be a futile exercise under 34(4) to remand the matter back. For example, there is a situation where mitigation of damages is not considered by the arbitrator. And the award could, of course, go because it will lead to unjust enrichment. So a party would have to consider that is it worthwhile for me to spend money and go back to the tribunal? And at least one party should find sense in that procedure. So only to ensure that it is not an exercise in futility, at least one of the parties must benefit out of that process, and therefore at least one of the parties should give consent to it. If the basis for such was party autonomy, then both parties should have consented, or the provision would have provided for both parties. But it only says only one party needs to benefit out of it. So therefore, only one party needs to request.
But what will be the scope for the 34(4) proceeding?
My
That's
lords.
actually formulated in an application. You are saying court will formulate it
My
in
lords.
order and take the.
My lords, I bow down to that, my lords.
Possible in all scenarios.
Right. So if I were just to go for the literal interpretation on what the tribunal can do once that order, once 34(4) is in cognizance of the court, there's two-level test. One is the means test, other is the ends test. The ends test says that the arbitral tribunal will enumerate the grounds. So the 34 court can lay down the grounds that, look, if you don't change your order, I will set it aside on these grounds. So you are hereby given an opportunity to cure these defects, if at all they are curable. And the means test is, what all can the tribunal do to eliminate these grounds? Take such other action as in the opinion of arbitral tribunal. So tribunal is at liberty. Now, this is not a remand under order 41 rule 23, 23A, 27, where the appellate court itself says that, look, you're supposed to do these things, and the consent of parties is not required. Here, the tribunal is at liberty. Tribunal has the opportunity to eliminate the grounds for setting aside the award. This is the interpretation. However, my lord, there are instances of Singapore judgments, which are also referred to in learned SG's submissions, where the courts have had put in annexure A to the order, and they have said, look, these are the 4 issues you need to determine now to cure the defects. And the matter has gone back to the tribunal to look into these 4 issues. Of course, there were subsequent disputes of what this order means and what the tribunal can do. But this is one way, my lords, I saw that the courts were exercising this power under 34(4). And contrary to Kinari Malik, my lords, we simply say there should be a written application, because my submission is it can be just a consent of the parties. And there are 2 judgments. One is of Madras High Court, one Calcutta High Court. I have referred to in my submissions. I'll just point out the parameters, I will not read it, which simply says it's a procedural requirement. Others may have page 5. Page 4 bottom. It's a thin submission. Well, so I'll hand it over. I have extra.
Yes.
I'm sorry, because one is not in the form of paper. Fine.
Yes, please. No, you're referring to this one.
My name is Pallav Mongia. My lord, should be filed in my name.
Yes, that's it.
That's the one. That's the one. Page 4 bottom is just a 8 pages submission. My lord.
Yes.
Page 4 bottom.
Yes, where we can refer to MMTC.
MMTC, my lords, absolutely, my lords. And must say, I won't read the paras, but my lords, though these judgments say they are procedural in nature, but my submission is it should be mandatory, but in form of a consent, not in form of a pre-application. It's not a trigger point. It's more of a case of ex post facto compliance. Because if the Because, my lords, once the court has made up its mind,
You can understand if you said that oral application, written application may not be necessary.
my lords,
When on an oral request it will be made.
my lords,
Then how can it be post facto?
no, ex post facto in the sense ki first the courts made up their mind and then they seek consent, not that after the tribunal exercise. My apologies.
Both.
I'm sorry.
Consent of whom?
Consent of one of the parties. Because it should not be an exercise in futility for the parties.
I think we're going in absolutely. Look, it's for the court to decide. Courts know how to deal with it. When objections are there, normally what happens? The party which is objecting, it can be two situations.
Right.
The party which is objecting to the award may come forward and say, please get it corrected. But the greater possibility is normally the party which is defending the award
Correct.
and
Correct.
gets confronted with a situation where they are not able to defend the award.
Correct.
They may ask them to be sent over there.
So that winning party will make a choice that, for example, mitigation of damages ground is not there.
The party which wants the award to be, defending the award. Like in a given case, it can be the other party.
Exactly, Milo. That's my point.
But normally a person which is defending the award, they find it's impossible to defend it. So they say, please send it.
Exactly. So
But
it may say that, look, mitigation of damages considered.
we should not now go into say how should application should be moved, whether it should be.
No, that's exactly my point, my lords. If my lords were to say that this is not a application
The
mechanism.
question is whether any modification can be done.
Correct.
Correct.
If
So
it can be done to what extent?
correct, my lords. Correct. So this is a process which will trigger that
We are
power.
not going to- process is very, the language is very clear, where it is appropriate and it is requested.
It is so requested. It is not an application.
So even if a party makes a request, the court finds that it is not appropriate,
Correct.
court may still reject it.
Correct. Now, I just point out 2 page numbers. I won't even take my loss to that. There are 2 Singapore judgments which are referred by the learned solicitor in his written submissions. And in the compilation 4, at page 1772, there are instances where the courts themselves said that you please address me on 34.4. The court invited submissions and it's recorded as part of the transcript, not just a recording in the law reports. my lords.
Yes.
What is the name of the Singapore case?
I'm sorry. my lords, one is Bagadia Brothers.
That's Indian case.
No, my lords, that's Singapore, my lords. Bagadia Brothers versus Ghanshyam at page 1772.
Volume 4. Yes.
In the first para itself, 4th line, my lords, on 12th April 2022. I'm sorry, Justice Vishwanathan.
Right, yes. Yeah, but what is the page? 177. Yes.
My lords, 4th line from the top, para 24. My lords have it, my lords. On 12th April 2022, I further directed the parties to address me on the applicability of 34.4 of the model law to the present application, and whether it would be appropriate in the present case to remit the award to the arbitrator. There was no application. In fact, an objection was subsequently
Why are you
taken.
going into all this?
I'm going for all this.
Courts
because-
know how to deal with this issue.
No, Milos, because it has been, Milos, in my humble submission, the requirement that it should be a written application, that may not be
Just
required.
leave that part.
And if it is so interpreted in such manner, then the power of modification indirectly comes.
We did not go into that question.
I bought a Milos. I just would want to share this. Then Milos, may I have just one more page on the next page? It's a chart. I'll just show that chart and I'll just end with it, Milos. Page number 8, there's a chart in my written submissions. Milos, may I have the chart? Just, I'm so sorry. I'll doubling it. Just 30 seconds.
So we have understood the chart. It says where there's uncurable defects, it has to be set aside. Where the
First-
curable defects.
Correct, Milos. There must
as
be
the
a
court will
under
try and
34.
solve it. If the court cannot solve it, then cannot, can be sent under 34-4.
Correct, Milos. And Milos, in the end, Milos, there's just one more.
Given by Mr. Datar.
Almost.
Milos, this aspect was not argued.
Used, it has to be sent back to the arbitral tribunal
Milos,
Be
in
modified.
priority, it should be used first, try and save.
by the 34 court itself, but it should be sent back to the arbitral tribunal.
No, yes, Milos, it should be sent back to the tribunal. The court itself cannot do it, Milos. That's my humble submission. And with regard to one question that fell from Justice Vishwanathan yesterday regarding whether quantum can change or not, Milos, there's one judgment of BRS versus BRQ. It's at page 1429, again a Singapore judgment, where the court itself noted that the quantum will change, but since it has to be sent back for the reasons aforesaid, all 34 grounds, therefore let that be the consequences. Because in my humble submission, Milos, this is not an opportunity for the parties to improve their case, but for an opportunity to the arbitrator to do a better job and ensure that the grounds are eliminated.
To remove the defects.
To remove the curable defects. Because of course, certain things can't be Milos. And conclusion is on page 9. And there's a summary of my submissions also on page 1. I'll end it. I'm obliged. Okay.
Listen. On this side.
But
No, you are the
I-
other
it
side.
cannot be modified because of the IA was like this. That's why
No.
I can be taken up. Milos.
Any other names?
Our bare bones proposition is that when your lordships are to locate the power to modify or vary, whether it is to be located as part of the power to set aside an award, which is a larger power, my lord, or is it a standalone power which stands in its own right, my lord? My lord, my submission is that as much as the power to set aside is a power, the power to modify is a power in its own right. my lord. But why I would say this is, I've handed over just 5 sentences note, my lord. My lord, all there, but these powers have not been expressly removed as well, my lord. So, my lord, in my respectful submission, my lord, the appellate court's power is to be traced under CPC, which says that the exercise of appellate jurisdiction, the appellate court can set aside the award, can vary the award, can confirm the award, or with the agreement of parties, my lord, is different kind of order can be passed. Now, my lord, so long as all these powers are subject to the express limitation on the power of setting aside, which is that the court in exercise of section 34 cannot review the merits of the matter, or there shall not be any reappreciation of evidence. Now, that's the test in my respectful submission. That is the test to be applied on all these 4 powers. The power to set aside, the power to refuse to set aside, the power to vary or modify, or the power to pass an order in terms of the agreement between the parties.
It's an appellate power.
It's an appellate power, my lord, which has not been taken away by this statute, my lord. The Arbitration Conciliation Act does not take any of the powers, my lord. My submission is that the express words relate only to setting aside. Right, my lord? But, my lord, the power to set aside is not to be seen as the power. Power to set aside is a power within the larger ambit of section 34. So 34 is the larger power in which, my lord, there is the power to set aside, there is the power to modify, there is the power to refuse to set aside, and there is also the power that if the parties are in agreement, then a different sort of an order can be passed, my lord. And the limitations only being this, that in exercise of any of these standalone powers, the court does not have to interfere with the merits of the matter or reappreciate the matter. But in that light, my lord, I have, my lord, taken liberty to just request your lordship to view the third referral question. Lord, the third referral question as framed is that whether the larger power to set aside entails the power to modify. Lord, in my respectful submission, my lord, if the words, my lord, if your lordship would have the second page, whether the power, and remove the words to set aside, and it may be read like this, whether the power under section 34 of the act, being the larger power. So 34 is a larger ambit, will include the power to set aside and the power to modify. So section 34, in my respectful submission, is to be read as a large power. Setting aside is a part of that power as much as the other three powers which I mentioned, the power to modify, the power to refuse to set aside, and the power with the agreement of parties. This is my respectful submission. Great.
Lord, sir, I need half an hour for the rejoinder.
Not just now,
Huh?
not just now, not at this time.
No, not at this time. No, but I'm saying that if they could never assist your lordships, my lord, my learned friends. If
Ask to
they-
let them complete and then you can.
That's what I'm saying, my lord, that it would be fair, my lord, that they assist your lordships and
Yes,
give me 20 minutes to half an hour at the end, my lord, when my friends conclude.
Yes, please.
Yes, I'll take a short while and then Mr. Banerjee will do most of the argument. We've prepared a common compilation between the three of us so that there isn't a repetition, and that's been filed, Millers. But there's one note that we prepared. What he says. This is coming shortly at the note is coming.
Ancestral compilation, the common compilation.
Yes, Millers.
Now there are
There
three
are
views.
six volumes.
There are three.
There's six volumes.
There are three views which are coming. Or we can divide broadly into three views. One is that the power to set aside subsumes in it power to modify, in which cases will you modify? When will the court exercise the power of modification? Will be relatable to curable defects, not something which are uncurable by the court. But this has to be done. One aspect, one side says this should be done without going into the merit or reappreciation of evidence. There may be some difficulty in that, because whenever we are going to the patent illegality public policy clause, there is element of reappreciation. But not as an appellate court, but as a court within the confines of that power. See that. The second issue which has been argued sometimes is that the court may not do it. It can always then exercise the power in appropriate cases under law section 4 to section 34. The third view is where the court can do it, it should do it. But where the court finds it, it cannot do it. And there is some way you leave it to the arbitrator to carry out that exercise. That's a argument.
I think one thing we must remember, and the other side certainly must remember, is that we are not indulging in some kind of a legislative exercise. This cannot be a de novo.
No, they have not argued.
And this-
They, none of them have said it's a legislative